Press record. There we go. All right. Welcome, everyone, and we thank you for joining us to the Chamber Presents Weed and the Workplace, What You Need to Know. We are glad to have David Thomas back. He is a partner at MichieHamlett. And if you remember, he did our COVID-19 and employer liability presentation back in March. And so David has come to just share some information with us. As we know, July 1st, cannabis became legal, but we want to discuss the difference between legalization and decriminalization. How does how does this new law impact drug testing policies in the workplace? And can employers prohibit marijuana use? And what are some of the rights that employees have? What are some of the things that employers can continue or discontinue? So David's going to come and give us some information on this and help us. So Dave, I turn it over to you, and thank you so much for being here.
No, happy to do it. Thank you, Andrea, and good afternoon, everybody. So as Andrea said, my name is David Thomas. I'm an attorney with MichieHamlett here in Charlottesville, about maybe 2 blocks up the street from the chamber. Fortunately, our internet appears to be working just fine, although let me know in the comments if anyone has any trouble hearing or seeing anything I'm doing, or I should say in the chat. You can tell I have young daughters that I refer to everything as the comments now. So when Andrea asked me about this, I sort of chuckled and I said to her, well, that's great. I'm happy to do it. We should probably schedule, 5-6 minutes for the whole presentation, including questions. And the reason I say that, and now we'll see, you heard that we were trying to get a PowerPoint working, and I said I could proceed without it because the PowerPoint here is very simple. So let's see. So now you're seeing the fun cover slide, and everybody says, okay, well, Virginia, marijuana is legal in Virginia now. Marijuana is legal in Virginia. What's changed for employers? And the answer is, if my PowerPoint will cooperate, nothing. Literally nothing has changed. The fact that marijuana has been, and technically decriminalized, not legalized, it's still technically illegal, they're just not going to prosecute it anymore. The fact that marijuana is now decriminalized under state law makes absolutely no difference in anything you are doing when it comes to your employment rules, your handbook, conditions of employment, and anything else. But how can that be? This was a major sea change. And the answer is no, not really, because, as I said, marijuana is still a crime under federal law. So all of those policies in your handbook which say you can be disciplined up to and including termination for violating any law, smoking marijuana is still against the law. Having marijuana in your system is still a crime. Possessing marijuana is still a crime. It's just a crime under federal law, at least for now. And so there really is no impact whatsoever. With one exception, as you'll note from the prior slide, there's a little asterisk after nothing. I'll come to that, but it's frankly not going to impact almost anyone who's on this Zoom call. So one, marijuana still illegal, so all of the policies that deal with illegal behavior, illegal conduct all still apply. Two, employers had and have the right to restrict basically what substances employees can have in their body if they can show a reasonable link that it could substantially impact work performance or present a safety concern. So the same rules that allow you to tell employees they can't show up drunk, right? Alcohol, perfectly legal, but the same rule that says they can't show up drunk says that they can't show up to work high on marijuana. They can't show up to work with marijuana in their system. And, tellingly, I have a partner whose wife is a federal government employee. All of the same marijuana rules still apply to her employment because federal law governs her employment. And so that remains true. And then finally, in the last point here, and it's, sort of the thing people always come to at the end of the day, employment in Virginia in most cases is still at will. So if an employer wants to have a workplace rule that says employees may not have marijuana in their system when they come to the workplace, when they do work for this employer, whatever the case may be, that is still a condition that you can say, okay, well, you don't have to abide by this rule. You just don't get to work here anymore. So for those of you on my vaccine mandate presentation a couple of months ago, at the end of the day, the same bottom line thing still governs the two. The employer, with a handful of exceptions that are beyond this call, can have workplace rules that they can justify in some way. And if employees don't want to abide by them, they don't have to work there anymore. All right, so I said there was one exception, and here it is. In addition to the decriminalization law that was passed, there was a separate law that was passed that provides that employers cannot discipline, discharge, or discriminate, so all of the Ds, against employees who are lawfully using cannabis oil. And so you'll see here the requirements, and if this ever becomes a situation, you'll definitely want to talk to counsel about dealing with the particular situation that presents itself. But I haven't, with any of my clients, this hasn't come up at all ever in any form. I have not gotten a single question about an employee who had a certification from a practitioner substantiating their need to use cannabis oil to treat a medical or mental health condition. And as you'll see in bullet point number 3, you're still allowed to take action if the use of the oil impacts or impairs their performance. So, as I say, technically there is one difference now. It's not from marijuana decriminalization. It's from an entirely separate bill. It almost never comes up, and the way to deal with it is, does it impact their performance in any way? Which of course always leads me to the one question I have when I get questions about, well, what if employees are doing X or Y or Z? My question is, if it doesn't impact their work performance, why do you care? Why do you care what they do in their off hours if it doesn't impact performance or, bring your business into disrepute? And so, the law, even this law that says people can now lawfully use cannabis oil under certain conditions, still has these requirements or these outs for employers that if it impacts performance, you can take action and you can prohibit possession of cannabis oil during work hours, and I really should say in your workspace. You don't have the right to regulate what people do at their own homes, what they have at home, but you can tell them you can't bring it to the office. You can't leave it in your car in the parking lot if the parking lot is controlled by the employer. Okay. So as I said, very short slideshow. I take it back. There was exactly one slide with meaningful information on it. The rest of it was mostly to amuse myself about the fact that at the end of the day, the decriminalization of marijuana in Virginia is going to have essentially no impact on what employers can choose to do with respect to workplace rules, their handbooks, or anything else. So that was the 6 to 7 minutes that I said would be necessary, although I had included questions in that technically. So I think at this point, does anyone have any questions? And Andrew, I can't remember how we handle this. Does somebody been collecting them, or do people just chime in or put them in the chat?
Well, we'll just open it up to those who are joining us. If they have questions now, feel free to chime in, or they can certainly write them in the chat. Let's see. Any questions, attendees?
So while people do that, sorry.
So when you say it's in their system, so marijuana, this is Mary Kay, by the way, from what I understand, marijuana can stay in your system, I don't know, like it can be detected in your urine or hair or whatever for a lengthy period of time. So that doesn't mean when you come to work that you're impaired by it. It just means that you have it in your system from.
Yep, you have an illegal narcotic in your system. I mean, you're right. I mean, I think it's like somewhere between 25 and 30 days that there is a measurable amount of THC that would show up on a drug screen. And so at the end of the day, like I said, you have a measurable amount of an illegal narcotic in your system. If you want to have a workplace rule that prohibits that, you can. Excuse me, I'm about to sneeze. Excuse me. Now, you know, all of this is what you can and can't do. There's nothing in here to say that employers have to outlaw marijuana. I've had conversations with other lawyers where we represent, let's call them manufacturers of alcoholic substances, breweries. And if they made marijuana in their system a fireable offense, there'd be nobody to brew the beer. And so there are plenty of people who may, I'm kidding, sort of. So there are plenty of employers who have decided that they are not going to, they're either not going to drug test or they are not going to make marijuana or having marijuana in your system a fireable offense. And that's permissible too. If they decide they don't want to punish that kind of behavior, or they frankly just want to look the other way. All right, so I see two questions. I'll just start from the top and go down. So one is, how should people proceed with requesting an accommodation if marijuana has been prescribed to treat a medical condition? So it's kind of the same way you would with any other controlled substance, any other Schedule I or Schedule II narcotic. If the person, or say somebody who's been prescribed painkillers, opioids to treat a post-surgery or another physical condition, you would do it in the same way. You would run through all of your ADA accommodation steps, and then with the ability, just like you would with the opioids, to make a determination whether or not having an employee who regularly uses a altering substance presents what's the word I'm looking for? A significant impediment, but that's not right, to their ability to perform their job. So, if you're Jaunt and you have a driver who says, well, I just, for my accommodation, here's my doctor's note that I need to be able to smoke marijuana 3 times a day, Jaunt's going to be able to say, you can't smoke marijuana and drive one of our buses. That presents a significant safety risk. That's not a reasonable accommodation. So in that sense, it's going to be, I would think of it just as you would any other accommodation that involves a scheduled substance. And then, do you anticipate changes in the next year or two? Are there other states that are predictive of Virginia's future approach? I don't anticipate any changes. That's mostly just my reading the tea leaves. I spent, the obligatory 18 months working on Capitol Hill. I'm from Northern Virginia. So I spent the obligatory 18 months working on Capitol Hill, but that was 20-some years ago. I just don't think that Biden and the Democrats are going to spend a lot of political capital on legalizing marijuana on the federal level, given the raft of other things they say they want to get done first. I could be wrong, and if at some point in time marijuana becomes legal under federal law, then the calculus, in some senses, the calculus will change, and in some it won't, right? I mean, at the end of the day, marijuana is still a substance that is capable of altering behavior, ability to react, reaction times. So I think it will, at least in my lifetime, or practice time anyway, always be the case that employers will be able to prohibit the use of or having marijuana in the system if it presents a reasonable risk to the employee's essential job duties. The Jaunt bus driver I referred to before, potentially an armed security guard. I'm trying to think of other examples, but I do think that will be the case. I suspect the more likely thing to happen is that as societal views on it change, you will have more and more employers who simply decide not to care about it anymore, right? And that's probably just a function of the views towards marijuana use and the way in which they change if you look at, potential age groups. Like people who are 70 plus have a very different view, well, maybe not actually, now that 70 plus includes the beginning ends of the baby boomers. But right, like my grandfather had a very different view of the use of marijuana than did my father, who went to Brown University in the 60s. And I, who went to Swarthmore College in the 90s and 2000s, have a very different view than he did. And, probably by the time my daughters are old enough to have a view on marijuana use, theirs will probably be different than mine. I think that's going to probably end up being the more significant. In terms of other states that are predictive, not really, because so much of this is still predicated on the idea that, two things. One, most of the laws that an employee would bring a claim under are federal laws anyway. So as long as marijuana is illegal under federal law, you're never going to be able to base a federal law claim on being disciplined for breaking federal law. And where you have state statutes, I don't know that I've seen anything where they run into that sort of supremacy issue. Like if an employer terminates an employee for having marijuana in their system, and the employee tries to bring a state law claim, say under Virginia state law, can they basically ignore the fact that marijuana is illegal under federal law and making that claim? I suspect the answer is no, but I haven't specifically seen it. Should use of medical marijuana be disclosed during a job interview? Ooh, there's a loaded question. I would kind of put this in the category of getting information in a job interview you don't want. Like asking a potential employee, do they have a disability? Are they gay? Those are sort of the two hot button ones, right? That's information that you very well may not, in fact, probably shouldn't want or get during the process. Because as soon as you have that information, it becomes something that the employee thinks may impact your decision in hiring or not hiring them for a job, right? So you may have, you bring somebody in and you ask a question like, so do you use marijuana medically, or do you have any right to use medical marijuana? And they say, well, I do because I have this disability, I have this condition. And then for other reasons, you decide not to hire them. Now, of course, all that's going to be in their head is, well, you asked about this, I disclosed to you this condition, and I didn't get hired. And for those of you who had to go through it, that's what we call a prima facie case of discrimination, which means that you end up paying me, or somebody like me, a fair amount of money even to win that case, because if they file it, it probably survives the initial round of pleadings. So, it's in that instance of you can ask. There's nothing against the law about making that inquiry. I just don't know why you'd want to in the front end. All right. If an employee is prescribed marijuana, might another employee make some kind of claim? Must the business provide a place to smoke? I'll be honest, I don't know the answer to the second question. I suspect the answer is no. I suspect the answer on whether or not an employer has to permit space for an employee to smoke on site is no. In part because, I know the cigarette debate is different, but obviously by this point we all know that employers can simply say no smoking on company property, period, full stop. And that's why you see people clustered across the street at various times throughout the day. So I suspect marijuana could be dealt with in the same way. And that being the case, then you wouldn't have a secondhand claim if all of that activity was occurring off of company property. All right, and then, sorry, a follow-up. My point of disclosing, so the question about disclosing the use of medical marijuana during a job interview. It's been a long time since I interviewed for a job, which is kind of nice, knock on wood. I don't know why an applicant would want to make that disclosure. Like, why would an applicant say, here's a thing that you might find problematic, and not hire me because, right? Because still the stereotype that old white men do a lot of hiring, and old white men tend to be the least tolerant of marijuana use. I think it's probably the same answer from the other side, which is there's no reason an employee couldn't disclose it. Why they would, I don't know, unless they were trying to backdoor in, oh, by the way, I have a disability, and now if you don't hire me, I'm going to claim that was why.
Any other questions for Dave? These are all good questions. Yeah. Do you want to share anything, Elizabeth?
Yeah, I'll tell a funny story and then give people
Okay.
time to type if they need to, and then if not. What's funny about the whole marijuana thing is they decriminalized marijuana, meaning it is no longer, you will no longer be criminally prosecuted for possessing, I think it's like up to an ounce, or for smoking marijuana in your home. It's still against the law to smoke it in public. But they did not relax the restrictions on it, and you can grow it, right? You can grow up to 4 plants. But they didn't relax the laws on importation, which means that it is illegal to bring marijuana plants into Virginia. It is illegal to bring seeds for marijuana plants into Virginia. And prior to July 1st, it was illegal to, in most circumstances, it was illegal to buy or sell marijuana plants or seeds in Virginia. And so what they've been referring to, at least in the legal community, is what we're calling the immaculate germination, meaning that on July 1st, a whole bunch of marijuana plants just started suddenly appearing, despite the fact that it was illegal to bring in the seeds, bring in the plants, buy or sell the seeds of the plants. So it's just a funny thing of, where did all these people get all these now legal plants? Well, they probably broke the law, but apparently we've all just agreed to look the other way on that for some reason. All right, see one more question. Are there any liability concerns for an organization that publicly supports marijuana legalization and use? I'm not quite sure how to answer that for the simple, it sort of depends on what your organization is. I think advocating for the legalization of marijuana is, I would imagine, going to be fine from a legal perspective in most cases, unless you are an organization like particular types of nonprofits that are prohibited from political advocacy. Yeah, and I'm trying to think of a good example. So I'm a member of a bunch of organizations, one of which I have to be a member of, the Virginia State Bar. The Virginia State Bar is prohibited from advocating on political issues like this one, but the Virginia Bar Association, a voluntary organization, is not. So I think that question is going to depend entirely on whether or not your organization is one which is allowed to engage in political advocacy, in which case I think the legalization of marijuana would be fine. More problematic if you were saying, you know, everybody smoke weed regardless of federal law. Advocating for the violation of federal law is still a crime, despite what some people may think about that fact. But otherwise, I think you'd be okay. And then a request to repeat the item regarding the use of cannabis oil not being a violation of the law. Okay, so there is a bill that was passed, House Bill 1862, and it is now recorded as, I had it written down and now I have lost where it is, 40.1-27.4 is the law in question. And it makes it illegal, or an employer is prohibited from, same thing, disciplining or discriminating against an employee who has a valid written certification issued by a doctor to use cannabis oil. And so that's just the medical use of cannabis oil, not medical marijuana. So the law distinguishes between the two of them. So basically, if you are in a situation where you have an employee who has the certification to use cannabis oil medically, you cannot discriminate against them or terminate them, discharge them, take other action against them on that basis, unless their use is impairing their workplace performance. Then you can treat it the same as you would an employee who showed up to work drunk. And then finally, are edibles treated differently? No.
So Dave, I'll be the first to admit, I only recently learned what edibles were or are. Could you share in case there's someone else on here like, what are edibles?
All right, well, here's where I reveal the fact that I am still, to use a throwback word, quite square. My understanding, because I've never actually, I'm not even sure I've seen one, is that edibles are simply an edible item that is prepared to contain THC, the same active ingredient that's in, the kind of marijuana you would think of as being smoked in a bong or a cigarette. I assume people smoke them in cigarettes. And so in that sense, it's designed to get at the same end, which is delivering THC into the system. My understanding is that they are treated exactly the same as the smoking of marijuana itself. They are indistinguishable because the reality is what they're punishing, federal law anyway, is the delivery of THC into the body.
Okay. Okay. You're getting a question?
I'm just writing a comment.
Okay. And we have a comment from our chamber president.
Yeah. So I had heard that as well, and I don't know a lot about it, that there are marijuana substitutes that are, they are not identical. They achieve the same effect, but because they are not chemically identical, they are not yet illegal under federal law because of the way Schedule 1 and 2 works. It's a definitional thing. And so I don't know if they'll get around to adding them like they did. If everyone remembers, like, gosh, now it's probably 10 years ago, that bath salt craze. You could buy bath salts at like 7-Eleven. They came in those little tiny beaker things. And you were supposed to use them, I guess, for effervescence in a bath, but everybody was in fact snorting them and causing all kinds of damage. And what they ended up doing was, and the defense was, oh, well, they're not on the list, so they're not illegal. And then what happened was Congress was like, okay, here you go. Now they're illegal. And so I don't know if that will happen with respect to the THC comparable things that you can go down and buy at the farmer's market. Sorry, nobody can see that I'm pointing. It's that way for me. As of right now, I mean, and the question is anybody going to care enough to do it?
Mary Kay says she's read that the synthetic can be extremely dangerous.
Right. I mean, for the same reason that fentanyl is so dangerous in the opioid crisis, because you don't know who made it. If you are, can't believe we're going to get into this, but this feels like one of those after-school specials. Grown marijuana is grown marijuana. My understanding is it may not work, but at the end of the day, you're smoking a plant. It's not going to hurt you that much unless something has gone terrifically wrong. Whereas a synthetic could have been made by anybody. It could have been made by a respectable lab, or it could have been made by Joe Blow in his bathtub. And you just have no way to know. But
I've actually heard the flip side of that too, in that the synthetic, oops, sorry, you turn your mute on.
I am in
Oh. Sorry about that. That the synthetics, because they're created in a lab, if they are from a reputable company, that they actually can be safer than something that's grown in the ground that has been possibly modified in ways to make it stronger, where you don't actually know how strong the product is. So I think there's still a lot to figure out with these products. And I was just really interested in that Delta 8 product because it seems to actually have exactly or close to the same effect as marijuana. And yet I don't see anything regarding making it illegal or regulating it in any way yet. So it's an interesting product.
We've now passed well outside my area of expertise. Anytime we stray out of liquids made in Kentucky or grown in Sonoma County, we're past my expertise. All right. Well, I don't see any more questions.
Well-
So at the risk of, Andrea, sorry, go ahead.
Anne Marie, do you mind closing us out?
No problem. Dave, why don't you wrap us up and then we'll just we'll close out the
Okay.
meeting.
Sure. Despite my being incredibly glib during the 7-minute presentation, I recognize there are a lot of questions and uncertainties. I'm happy to answer any questions people come up with after the fact. David Thomas, MichieHamlett, I used to say we're in the phone book. You can find us online, michiehamlett.com. My email address, dthomas@michiehamlett.com. And so feel free to shoot me an email if you have any questions or concerns, or I also enjoy humorous anecdotes, just because sometimes it's nice as a lawyer to not have someone call you up and not have a problem. But otherwise, thank you all very much. I appreciated the opportunity to speak with you.
Thanks very much, David, for being here. And do we have any other final questions before we finish? Okay, I appreciate everyone being here as participants. Please let us know if you have other legal type questions that you'd like us to cover in the future. We are always happy to call up David and see if he's available to join us again and answer other questions, speak on other topics. So thank you for being here, and get in touch if you have any other questions.
Thanks, everyone.